If you want a peaceful divorce that keeps you out of court, your best two options in Florida are uncontested or a collaborative divorce. So in this video, we're going to explain the differences and help you pick the one that best fits your life. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group here in Miami. Our mission is to make lives better in and out of family court. My firm has handled thousands of divorces, and sometimes hashing out a divorce through the traditional litigation process is the only way. But whenever it is possible to go the uncontested or collaborative route, it's usually faster, less expensive, and generally better for everyone involved. So here's what we're going to cover in this video. I'll explain uncontested divorce in plain English, what it is, and what can go wrong if it's handled incorrectly. Then I'll walk you through the collaborative process, the team, the meetings, and how decisions get made. I'll show you the time and cost ranges and why they're different. And at the end, I'll give you a side-by-side checklist to help you pick the best path. But before we begin, just know that this is only about divorce in Florida and isn't legal advice for your specific situation. So first up, uncontested. Now technically, uncontested means that when we file the divorce petition with the court, everything has already been decided and agreed upon, and there's no need to litigate absolutely anything. So even a collaborative divorce is technically filed as an uncontested one. But in practice, to go the uncontested route means that you agree on everything, even before you talk with an attorney. How property and debts will be divided, your parenting plan and time sharing, child support, alimony, all of it is decided and usually written down. Now, you might be thinking, if we agree on everything, what do we need the lawyers for? And it's a really good question. Technically, you don't. You can absolutely go to the courthouse and fill out all the paperwork on your own in what's called a pro se or self-help divorce. But here's why I don't recommend that. You don't know what you don't know. And I've seen so many cases where people agree to things that were not in their best interest. They gave up rights they were entitled to or made agreements they didn't understand and couldn't possibly uphold. So even though the divorce was very quick, they ended up with a huge mess and a lot of resentment that they have to live with now. And then sometimes people don't even finish the divorce. They separate and live like they're divorced, but the process and paperwork was so overwhelming, they stayed legally married for years. That's a huge liability because there's no such thing as a legal separation in Florida. You're either married or you're not. And while you're married, your spouse maintains their legal rights. That means they're entitled to any appreciation on assets and investments you made after you first got married. So if your business takes off or your portfolio is doing great, they're going to be entitled to half of that value. And God forbid if something were to happen to you, in many cases, your legal spouse is first in line to inherit anything you own and to decide whether to pull the plug or not. You do not want that kind of liability hanging over your head. So even if you're in agreement now, make sure that you work with a family law attorney that focuses on family law, like the ones on our team. We'll make sure you understand any agreements you could regret later and take care of all the paperwork for you. But what if you don't agree on everything? You can still avoid all the courtroom drama with a collaborative divorce. Collaborative divorce is a team-based, no-court process that helps you work through the things you don't quite see eye to eye on. On that team, there's two collaboratively trained attorneys, one for each of you to represent your best interests. A neutral facilitator or divorce coach. This is your communication and parenting guide. And a neutral financial professional. This is who helps you work through your numbers and value your assets and debt. And if we need the help of other neutral professionals like a CPA or a child therapist, we can bring them onto the team as well. The key that makes the collaborative process work is that on day one, everyone signs a participation agreement. It says we'll stay out of court and negotiate in good faith. If the process collapses, the lawyers must withdraw and you have to hire a new lawyer for court. That rule keeps everyone invested in solutions because otherwise you have to start from scratch. When the team meets for collaboration, the financial neutral gathers documents and builds simple summaries of your budgets, your assets, and your debts. The facilitator keeps the tone steady and helps draft a parenting plan if you have kids. Then we brainstorm options and trade simple, data-driven offers. And here's one of the biggest benefits of the collaborative process. All the negotiations are private. In a traditional divorce, everything you submit into evidence, including your financial statements, go into the public court record. But with collaborative divorce, the only thing filed in court is the final marriage settlement agreement. The collaborative process is also great because the private meetings are easier to schedule than court hearings. You can often solve more in weeks than in months of motions. You're also writing the outcome together, so people are more likely to follow it later. But unfortunately, collaborative doesn't work in all situations. If there's zero trust or safety is at risk, if one of you refuses to share information, or if either one of you are coming into it with a win-lose attitude, the collaborative process is not likely to work for you. This is about collaboration, working together to achieve the best possible outcome. And that takes both of you committing to put your differences aside and seeking a solution. So now that we know the basic differences, let's talk about the differences in time and cost. Uncontested is usually the fastest lane. Once all your paperwork is clean and filed, many cases finish in about 30 to 60 days. The fastest it could be done in is 20 days by law. And after that, it really just depends on how backed up the judge's calendar is. You don't typically have to go to court, but the judge still has to review your case and sign off on your agreement. As far as costs go, it will depend on your attorney, but many firms, like ours, will handle a truly uncontested divorce for a simple flat fee. Just know, however, if anything goes sideways, your legal fees will go up. If you need to go the collaborative route, it will take a little longer, but still typically be faster than a contested divorce. Most families I've seen finish the process in about 3 to 6 meetings with their collaborative team, and that generally takes about 3 to 6 months. Because there are a lot of unknown variables, most of the time, you'll be paying based on the hourly rate of your attorneys. Collaborative is generally going to cost more than uncontested because you and your spouse have to pay all the professionals involved, but it is still often less than a contested divorce. Now, if you're still not sure which one is right for you, let's go through 4 quick checklist questions. Number 1, communication. Can you talk respectfully and follow through on what you say? If yes, uncontested fits. If it's a little tense, but you handle it with help from a facilitator to keep things calm, collaborative could work. Number 2, agreement. If you're in full agreement on all terms, uncontested can work. If you still have some sticking points to solve, but are willing to negotiate and work together, collaborative could be the right move. Number 3, trust and transparency. Are you willing to exchange honest, full disclosures without drama? If yes, uncontested fits. But if you'd feel better with a neutral third party to organize, verify, and explain the documents, collaborative would be the way to go. And number 4, complexity. Uncontested really works best when it's simple. You only have basic assets, a parenting plan that is going to be straightforward, and realistically, there's no need for child support or alimony. But if you've got a business, significant assets, or sensitive parenting issues like a special needs child, it's usually best to go through the collaborative process. I can't tell you how many times I've seen a divorce where the couple was sure it was uncontested until it wasn't. And it often has to do with a disagreement they didn't realize they had about the money or the kids. Now, if you were able to check off uncontested for each of those, congratulations. You could potentially get your divorce done within a month. But if you check collaborative for any of them, it's really an option you should speak with an attorney about. Just make sure they're actually certified in collaborative divorce. Now, I've talked a lot about agreement in this video and how you need to be in agreement or at least willing to collaborate on all the terms of your divorce for uncontested or collaborative divorce to work for you. But what are all terms? There's a lot of things that people aren't really aware of. That's why we made a divorce readiness quiz. It's free, it's private, and it only takes about 3 minutes. And it doesn't just touch on the legal aspects of divorce. It would also help you think about the emotional and practical things a lot of people haven't thought about when they talk to an attorney. And don't worry, it's not like a school quiz. It's going to test your knowledge on legal terms. What it will help you see is how much thought you've given to it and how aware you are of the process. The link is in the description. Just remember, it's just an informational quiz, not legal advice. And if you know you're ready or there's an urgent need, you can call my office for a free case evaluation or schedule on our website. That link will be in the description too. In our next video, we'll unpack what turns an uncontested divorce into a contested one, the common pitfalls, why they happen, and the simple fixes that can keep your case peaceful and moving forward. Until then, I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court. See you soon.